For how we got here, what we have is a situation where the White House and DOL were perceiving there to be significant conflicts of interest that were permitted in the sale of certain, well, in general in financial advice, but for our purposes here, particularly focusing on certain types of annuities and some insurance contracts. And so they wanted to basically not allow these conflicts. And so they did that in a two-step process. First, they expanded the definition of what constitutes fiduciary advice. And that has the effect of making these prohibited transaction rules that are in ERISA and that are in the tax code apply much more broadly. So the effect of that expansion of advice is that basically when somebody recommends, an agent or producer recommends that you purchase an annuity or you purchase an insurance contract, that may well become fiduciary advice. In the case of an annuity, and we'll talk about exactly when that applies, but that probably becomes fiduciary advice in a lot of circumstances, and then results in these prohibited transaction rules affecting how the carrier, how the agent, how everyone can be paid in connection with that. And then the second step, after making that advice fiduciary and therefore making some common forms of compensation illegal, the second step was to put in place what are called prohibited transaction exemptions to nonetheless allow some of the things the main rule just made illegal to happen anyway, subject to some certain additional conditions.